On April 17, 2024, NYU School of Law hosted a panel of experts to discuss whether a former president enjoys immunity from criminal prosecution for conduct that allegedly involved official acts during his tenure in office. The Supreme Court is also considering that question in United States v. Trump, and will hear oral arguments in the case on April 25th. The panel consisted of George Conway, a contributing writer at The Atlantic and the board president of the Society for the Rule of Law, Trevor Morrison, the Eric M. and Laurie B. Roth Professor of Law and Dean Emeritus of NYU School of Law, and Kate Shaw, a professor of law at the University of Pennsylvania Carey Law School. Andrew Weissmann, a Just Security editor and faculty co-director of the Reiss Center on Law and Security at NYU School of Law, moderated the discussion.
It's nice to see so many students here, so welcome to the NYU Law Forum. I'm Andrew Weissmann, and we are going to discuss today something that is a very hot topic because a week from tomorrow, on the 25th, the last day of the Supreme Court's term, there will be an argument on presidential immunity, and we will get into what exactly the background of the law is, what legal issues are being posed, and we have some good hypotheticals, and then we'll hopefully have some time for questions from you all. I think you probably all know our distinguished panelists. It's a perfect panel to address this. So starting to my left is George Conway, who I think of, I'm going to really date myself, as the George Plimpton of our generation. They're like, okay, so they got no response.
No response.
Exactly, by the way.
But that's what Google is for.
Yes, exactly. And now you know what my students have to suffer with, where I make jokes and I have to announce that it is a joke in order to get any sort of response.
Same.
George is a longtime partner at Wachtell. He is a contributor to The Atlantic. And for today's purposes, also has some unique background on presidential immunity, having worked on a case involving Bill Clinton and civil liability with respect to a sitting president for conduct prior to when the president was the president. And to his left is Kate Shaw, who is a professor at the University of Pennsylvania, and is also, some of you may know, a co-host of an incredibly great podcast that I can't recommend highly enough, called Strict Scrutiny with Leah Littman and also our own Melissa Murray. And if you are trying to follow what is going on in the Supreme Court, there is no better way than to listen to the three of them. And you have the unique ability, I think, since you worked in an administration where there seemed to be no civil or criminal issues with respect to the president, you have not been in a situation of either bringing or defending a criminal or civil case against a president. So you have that against you, but in your background.
And I should say it was not because Trevor and I lawyered Barack Obama's presidency so well. He was just sort of always by the books and adhered to the law in every moment.
That's our position, and we're sticking to it.
Exactly.
And then certainly this is somebody who definitely needs no introduction to this crowd, the former dean, Trevor Morrison, who also has a unique background because he was involved in the recent civil cases that were brought by E. Jean Carroll in connection with conduct by it's a civil case with conduct of a former president. So all of that's going to be relevant to the issue that's before the court, which has to do with a federal criminal case, a federal one, not a state one, with respect to conduct of a former president relating to activity while that person was in office. So maybe that's a way to begin the discussion. And George, can I ask you, given especially since your background in respect to the Bill Clinton case, if you could maybe set the table with respect to where is the law with respect to sort of civil immunity with respect to either former or current presidents, and whether it relates to conduct in office or out of office?
Yeah. It's really quite simple. I mean, it derives from a long line of absolute immunity cases in which officers of various sorts were held not to be liable for their conduct, even if it caused some harm. And that it involved judges. There was a long line of Supreme Court authority, but the cases were all civil cases. And it came to the Nixon era. Nixon was sued by, I think it was like a former Air Force officer named Fitzgerald, and I forgot what exactly his beef was, but he alleged that Nixon had done him wrong by causing him, I think, to lose his commission. And he brought a civil case against Richard Nixon. And long story short, it went up to the Supreme Court, and the Supreme Court ruled by only a 5-4 margin in favor of then former President Nixon. And it went through all these civil liability cases and distilled from those cases basically a principle that it kind of beefed up for the president. And the rationale was, well, the president does things that affect a lot of people because he's president of the United States. He's got so much power. He's got to do all these things under the law. And if you say that somebody out there who's harmed by his alleged, could be valid, could be not valid, failure to comply with the law, and you say that he's civilly liable, personally liable, what president is going to be able to do his job? And from that, they basically derived the standard for presidential civil immunity for conduct allegedly violative of law and harming a civil plaintiff. And the standard is that if the conduct that is alleged is within the, and here are the magic words, outer perimeter of the president's official responsibilities, then there can be no claim. The claim should be dismissed. And that was the law, that's been the law since the 1970s when Nixon against Fitzgerald was decided. Interestingly, it was only a 5-4 decision, but it's now accepted law. And the next time it ever came up was in the Paula Jones case, and that was a case in which President Clinton was alleged to have, while he was governor of Arkansas, before he had run for president, had a state trooper bring a woman up to his hotel room that the state, for some reason, had rented at the Excelsior Hotel in Little Rock, Arkansas, and the state trooper brought the woman up to the hotel room, and then he propositioned her in indecent fashion, the allegation was. And the argument that Clinton's lawyers made, supported by the Justice Department, was essentially that, it was first styled when it was in the district court as an immunity argument, but it later became an argument saying, the idea behind Fitzgerald is that it's not just about the liability, it's just that we can't take up the time of the president with personal litigation. And again, the problem with that is it's not consistent with Fitzgerald, because Fitzgerald was talking about official immunity for official acts. And there were instances in the past of presidents being sued for conduct that had nothing to do with their office or preceded their assumption of the presidency. I think Truman had been sued. I think John Kennedy had been sued. There was even a criminal case at one point where I think Ulysses S. Grant was speeding down Pennsylvania Avenue in his carriage, and a policeman arrested him. We'll probably get to that later. But basically, in Jones v. Clinton, Clinton v. Jones, Clinton lost 8-0, or was it? No, 9-0. And there was one concurring opinion where Justice Breyer said some things that I frankly don't understand. But But that was the state of the law. That's the state of the law on civil liability.
So, Kate, maybe now take us to criminal liability.
Sure.
So why doesn't the court just say, so that's the standard in civil cases, how do they differentiate? Where are we in terms of the state of the law? And then maybe also, particularly with this case, what is the record that is before the Supreme Court in terms of both what Tanya Chutkin, the district court, and then the DC Circuit held? So sort of why is this a big deal? Why isn't what George said sort of the governing position in the criminal context?
I might actually flip the kind of like orientation of that question and say it is what Trump is asking for is an unprecedented extension or expansion of the absolute immunity rule of Fitzgerald to the criminal context, which is something no court has ever accepted. And I think everything in our history and constitutional structure and the discussions such as they are in the cases and executive branch practice and things that Congress has said, all of that seems very clearly to render the argument that Fitzgerald should just apply wholesale, create absolute immunity from criminal liability for former presidents forever, is totally indefensible. So I think that the burden, in terms of sort of how we orient or frame the debate, is just on Trump to make the case that this purely civil doctrine that is broad in certain respects or is powerful and that it's an absolute immunity. But I actually think this outer perimeter language is important because it, I think, does suggest that there is a boundary beyond which, even civil liability is possible for conduct taken, by someone who's a president, so long as they are acting beyond the outer perimeter of their official duties. But that's obviously not what we're talking about here. We're talking about the possibility of, criminal liability for an ex-president, and the argument that he is making is that everything that he did while, plausibly presidenting is subject to the same rule of absolute immunity as the sort of civil rule that the court announced in this divided case in Fitzgerald. So in terms of how he's making the argument for the extension or expansion, I think a couple of things. One, he is arguing that no president has ever been criminally prosecuted, and so that suggests that it's somehow improper or constitutionally impermissible. He is arguing that that allowing for a criminal prosecution like this would chill presidents from being able to fully and energetically exercise the office of the presidency. He is arguing somehow, I would love to get the very smart people on this panel to help me understand what he's really, the Marbury versus Madison argument that he is making. He's somehow suggesting that Marbury renders all of the president's official acts outside of the ability of courts to examine them, and there is language to that effect in Marbury, but I think it's completely distorted in the way it's represented in the briefs. And I think finally that the Constitution has a mechanism for impeachment and removal, and that only if a president is impeached and convicted and thus removed from office, only after those things happen can there be a criminal prosecution against someone who was the president when the conduct at issue occurred. And maybe just like to briefly say a couple of things about these. I do think that there's some really powerful historians' briefs, amicus briefs filed in the case. There is yes, there is no example of prosecutions of previous sitting presidents or ex-presidents for conduct taken while they were sitting. But everything, insofar as history matters, it's entirely clear that sort of founding era assumptions about presidents and accountability make crystal clear that it would be unthinkable for the court to announce this principle of absolute immunity from criminal liability. So I do think history is very powerfully on the side of Jack Smith and the prosecution and not on the side of the president, or the ex-president. On Marbury, I think that accepting this idea that Marbury says that presidential conduct is not judicially examinable would throw into question everything from like Marbury itself, which does say some executive conduct is examinable, even though in that case, the court finds that it doesn't have jurisdiction, but also cases like Youngstown, United States versus Nixon, like many, many other cases. And so I just don't think there's anything to support that proposition. The court not only has never embraced the argument that Trump is making, but I don't think has ever suggested there's any analogous criminal immunity like the civil immunity from Fitzgerald. And insofar as there are mentions, in Nixon versus Fitzgerald itself, there is a suggestion. We're talking narrowly about civil cases. There is a lesser public interest in actions for civil damages than, for example, in criminal prosecution. Fitzgerald itself, I think, seems to distance itself from the possibility of its direct application in a criminal context. Great John Marshall in the Aaron Burr case suggests that presidents can be compelled in some circumstances by courts to respond to criminal subpoenas. Obviously, the court in the United States versus Nixon case compels the production of the Oval Office tapes by the then sitting presidents. Insofar as you think that not just history and not just the things the Supreme Court has said or done matter, but things like executive branch practice matters, I think that Trevor is obviously the expert on this, but at Office of OLC opinions and also just the conduct of former presidents, I think, make really clear that everybody, or that nobody believed that the argument that Trump is making, and has repeated enough that it comes to seem like a reasonable argument, but I don't think repetition makes something reasonable, that, no one assumed that there was an absolute protection from criminal liability for everything that a president did during his time in office. And I also think maybe, Gerald Ford's issuance of a full pardon to former President Nixon, had as a presupposition that otherwise there would be the prospect of a criminal prosecution. Otherwise, why a pardon would be necessary at all, I think, is a real question. And maybe I'll stop in one moment, but say that to the extent that there's other precedent that matters, I dug up Mitch McConnell on voting to acquit Trump, right, in the second impeachment trial, says, we have a criminal justice system in this country, we have civil litigation, and former presidents are not immune from being held accountable by either one. And that's not to say that answers the constitutional question, but I do think that insofar as we think the fabric of constitutional law is the product of all these things, I think they make really clear that there's nothing sort of substantively to support the argument that Trump is making. Sorry, I went on for a long time.
No, totally fine. For the Supreme Court, the record before it is they have obviously the allegations in the indictment. Normally, the court is supposed to accept those as true for this purpose. It has Tanya Chutkan's decision, which is sort of an absolutist view that there simply isn't criminal immunity in this setting for a federal prosecution of a former president. And then that went to the circuit that affirmed her in slightly different reasoning. And so I have a sort of quick question to all three of you that I'm going to sort of borrow from Trevor's framework in his piece for Lawfare, and then turn it over to him to explain sort of his reasoning. But if you take the sort of three views, which are, do people agree on the panel with Judge Chutkan that there simply is not criminal immunity in this circumstance of dealing with a former president for federal prosecution? That's sort of one absolutist view. The other is that there always is, the sort of Nixon v. Fitzgerald, and the other is maybe sometimes. And so, George, where are you? And there's just gonna be like a quick round, and then is it sometimes, never, or always?
Very rarely.
Okay.
I do think there would be some extreme circumstance where if Congress passed a law that was directed at the president that actually did prohibit him from, or her from, exercising authority that is uniquely presidential, yeah, that would be, and I think my thinking about this is pretty similar to Trevor's. I mean, essentially you've got Youngstown, you'll explain the three levels of Youngstown, and the lowest ebb is when the president does something that is contrary to the will of Congress. Well, what President Trump did here was it was in the basement. It was not even, it didn't even reach
Right.
the lowest ebb. It was not only something, he was doing something that Congress couldn't authorize him to do, which is to violate the provision that says a president's president for 4 years.
Kate, do you have a
I want to sort of mostly cede my time to Trevor, who I think has a very developed view on this. I think that essentially an absolute immunity argument that applies to all official acts or all acts taken within the outer perimeter is indefensible, as I was saying previously. I wouldn't rule out the possibility, maybe this sounds non-committal, but as George was just saying, there may be tiny pockets of presidential authority where I don't know if I would even think about it in immunity terms as much as a substantive defense of unconstitutionality rather than a front-end immunity, but maybe very narrow, sort of like pockets of unique presidential authority might be difficult constitutionally to reach using an ordinary criminal statute or a criminal statute passed specifically to target the president. But I certainly don't think the court needs to reach any of that here.
Trevor, so you have written about this sort of the always, never, and maybe sometimes, but it does, I think you're in George's camp, doesn't apply here.
Yeah, that part's clear. First of all, hello. Glad to be with you. Just to be clear about what Andrew was just asking us, I think we are all in agreement that there is no immunity in this case. And even if immunity is the wrong term, there is no constitutional bar to the prosecution proceeding in this case on the allegations that have been made in the indictment. The question then, kind of beyond the particular allegations in this case, one way to frame it, which would bracket Kate's point about whether immunity is the right way to conceptualize a limitation, is to ask, are there any constitutional limitations flowing from the fact of the presidency and the authority of the presidency and the role of the president, any constitutional limitations on the prosecutability of a president for conduct taken in his official capacity as president? I think that's what official conduct means to refer to. Let me just drop a footnote there. That's the question, when, if ever, is there immunity from a criminal charge for conduct taken in official capacity is basically the question presented in this case. There's a really important sub-question there, which is how much of the allegations in the indictment involved official presidential action, as opposed to, say, conduct taken by then President Trump in his capacity as candidate for re-election. The DC Circuit has an opinion in a case called Blassingame, which involves an assertion of Nixon versus Fitzgerald's civil immunity in a civil suit. He's being sued for January 6th related activity as well as being prosecuted. And the court there, Judge Srinivasan wrote, I thought, quite a thoughtful opinion making this point and saying it may be hard in some cases to figure out the difference, but it is conceptually possible for a sitting president to take actions in his capacity as candidate, not president. And federal election law assumes the possibility of drawing that distinction. And that would be an example, for perhaps even in the Nixon versus Fitzgerald context, of something happening beyond the outer perimeter of his official responsibility. So that is not part of the case, this criminal case as it now comes before the Supreme Court, which is to say, even if Trump won on his outlandish argument of immunity, it would remain to be determined whether any of the allegations in the indictment allege conduct that's not official acts by the president and instead just say conduct taken by him in his capacity as candidate. And however the court rules, that may be something that has to be sorted out below. Okay, that's all throat clearing. What do I think on this? The answer to the question I posed, does the Constitution impose any limits on the prosecutability of a president for his official conduct? My answer is yes. And I think most people's answer is yes. And I think most people would say they're very, very rare, as George said. And the framework that I've found useful, and there are a lot of my con law students here, I should call on one of you to recite all of this, but it comes from Justice Jackson's famous concurring opinion in the Youngstown steel seizure case, where he said a couple of interesting things. One is, and he said this in the early 1950s, that a justice or judge coming to questions of executive power for the first time may be surprised by how few useful judicial precedents there are on the matter. And 80 years later, that's still by and large true. So one has to try and come up with positions with a relative poverty of on-point judicial decisions. But the basic framework he laid out there is to say, when you want to figure out what authority the president has, what really matters is what has Congress done. And if the president acts consistently with what Congress has authorized him to do in legislation, then his power is as great as it could be because he has all authority the Constitution gives him and all authority that Congress has given him in that statute. If he acts in the face of congressional silence, like Congress hasn't said anything one way or the other, he acts in a zone of twilight, where it's going to be hard to draw clear lines because perhaps Congress could lawfully prohibit him from taking the action, but perhaps he can act as long as Congress hasn't told him he may not do it. And then if he acts in the face of congressional prohibition, his power is at its lowest ebb, which means, presumably, that most of the time the president may not act contrary to congressional prohibition. But we know from recent cases that there are some instances where Congress has tried to limit the president's action, and it has done so unlawfully. The most recent example before the Supreme Court is the Zivotofsky case, which involved a statute signed into law by President Bush, but he issued a signing statement basically saying, I'm going to ignore the part that I think is unconstitutional, that gave parents, U.S. citizen parents of a child born in Jerusalem, the option of insisting that the passport of the child identify the place of birth as Israel. Now, the practice of the United States for decades up until then had been, if the person was born in Jerusalem, it would list as their place of birth Jerusalem, not Israel, in order to avoid taking a position on the question whether Jerusalem is part of Israel. And the United States had maintained a studied ambiguity on that point for many years. Zivotofsky's parents sued, saying, we want it to say Israel. The executive branch said no. That issue ultimately was decided by the court with a holding that the statute impermissibly intruded on the president's exclusive power to recognize foreign governments, including the territory that they represent. So if Congress were to criminalize the president's failure to list Israel as the place of birth, that statute would be just as unconstitutional as the one that was trying to force that action in the first place. I regard that as an illustration that there are some domains where the president should be deemed immune from criminal prosecution. But it would be possible to say that that's not the right way to use the immunity term, that what we're really talking about there is a substantively unconstitutional statute. Sometimes we use immunity to refer to things that where the person being sued or prosecuted has the lawful authority to take the action they can do, and the authority they have trumps the law that's being, no pun intended, trying to be used against them. That's the conception in a related context called supremacy clause immunity, which involves the immunity of federal officers from certain kinds of state criminal prosecutions or civil suits. But sometimes, as in qualified officer immunity, we're using immunity not to talk about the substantive unconstitutionality of the underlying law you're trying to enforce against the person, but to say even if they acted unlawfully, they are immune from this penalty in this suit. So there's a kind of nomenclature debate there. But to me, the big point is this, and this is why I bothered to try and write that little essay in Lawfare laying out my thinking on this. Trump's litigation strategy is to tell the Supreme Court, unless you find me immune in this case, you will have no ability to protect presidents from criminal prosecution.
From him.
Maybe from him. From criminal prosecution when they act in core fulfillment of their constitutional responsibilities. He's saying it's all or nothing. And it isn't all or nothing. And actually, Jack Smith's brief, the special counsel, doesn't sign up to the limits that I've just described as immunity, but he enumerates a bunch of them. One is a kind of as-applied constitutional defense against prosecution if a president is being prosecuted for conduct taken at the core of his constitutional responsibility. Another is a kind of tactic of statutory interpretation that says that if a prosecution would implicate core presidential responsibilities, we should assume Congress didn't mean the statute to cover the president, unless it said so explicitly, so-called clear statement rule. Those things, for me, all come to the same place. The point is, I think, to convince the members of the court who are concerned about the legitimate prerogatives of the executive branch that those prerogatives can be protected without having to distort immunity doctrine to cover what Trump is alleged to have done in this case.
So let me give you a hypothetical to sort of flesh out, even though it's clearly not this case, but sort of where the line is. So let's assume that Congress tries to pass a criminal statute, and let's leave aside for the moment Kate's point, which I tend to agree that whether you call it immunity or whether it's just you just don't have the authority to do this, it would be struck down as unconstitutional invasion into the separation of powers, whichever it is. And let's say the Congress says, you know what, we now are, this obviously could never happen, but that's a joke. We think that supporting Ukraine is anathema to the United States public interest. We think that any support of Ukraine is going to be, will analogize to what we have done in the terrorism context, where we cannot support terrorist groups. No funding can go to Ukraine. It is now a crime for anyone to authorize that. And the president then goes ahead and says, you know what, this is uniquely something that was in my province. And then that's just to make that more analogous, he's now out of office and gets criminally prosecuted for violating that criminal statute. Is that an area that under the sort of the Justice Jackson tripartite rule, is that something that would be uniquely within his province? And so there should be some, whether you call it presidential immunity or it's just not a lawful statute as applied to the president.
So I think the straight up answer under the doctrine we have, the limited judicial precedent we have, and frankly, all of the Office of Legal Counsel precedent, is we don't know. There's a mistake made. My con law students know about this mistake, so they know not to make it, but here's a reminder before the exam. There are many Office of Legal Counsel opinions saying the president has the inherent authority under Article 2, principally under his authority as commander-in-chief, to direct the use of the military power, even in the absence of congressional authorization, even though it's Congress's power to declare war, not the president's. But all of those cases, not some, not most, all of them are situations where Congress has not, by statute, prohibited the military action in question. There's a mistake made by some executive power maximalist scholars, some of whom have occupied OLC at various points, to say that, well, if the president had the power to do it when Congress had said nothing, in other words, if the president had the power to do it in that zone of twilight in the Youngstown framework, then that means the president can do it at the lowest ebb too, even if Congress tries to prohibit it by statute. That's a literal category mistake. The whole point of this framework that Jackson gave us is to see the very consequential difference between presidential action in the face of congressional inaction or silence and presidential action contrary to statute. So the question would be, what, if any, of the president's commander-in-chief power is immune to congressional regulation? And there are all kinds of examples we can ask. This hypothetical you've posed is much harder than, say, the SEAL Team 6 hypothetical posed by one of the judges on the DC Circuit panel. Or for that matter, even the Anwar al-Awlaki question, could President Obama have been prosecuted for ordering a drone strike on a US citizen? In that circumstance, the Office of Legal Counsel took the position, among other things, that the federal criminal statute at issue did not apply because of something called a public authority exception. It's another way of protecting executive prerogatives without having to use a doctrine of immunity. But also that this action was taken not in the face of congressional prohibition, but with congressional authorization in the form of the 2001 authorization to use military force. Andrew's hypothetical is challenging because we're confronting this lowest ebb situation.
Well, also, it's challenging because the way you phrase it, I think, I'd have to go back to a transcript, which we won't have, is you phrase it in terms of, I think you phrase it in terms of the spending power, which is actually Congress's power, right?
Yeah, so I think it's even greater. The idea that the president could,
misappropriate or take money out of the Treasury that was allocated for one purpose or not allocated for the purpose that is prohibited by the Weissmann Act.
Right, but you could hypothesize just to play, I don't know, devil's advocate. So suppose there's a general prohibition on use of those funds to undertake some particular military operation, in part because Congress does not think that foe is a true enemy of the United States, and then it turns out that they conduct an attack directly on the United States. Could funds be used to repel the attack? I think probably yes.
Yeah. Plus there are ways to get around the funding issue, which the current president has actually done to try and use already appropriated funds in ways that to assist. So, and that would be a technical violation because there would be funds going in the same way that in a terrorist case that the law is incredibly expansive. So again, it was trying to be sort of very
it's a very good hypo. Yeah.
Okay, so
now I can't use it on my exam.
This is it's such a great position to be able to ask like hypotheticals of these folks. And then, by the way, we're going to leave time so that you can ask your own very difficult hypotheticals, which just shortly before exam. So be careful. So, Kate, I have a similar hypothetical, but this is one that is very dear to my heart. So before coming here, this is like everyone always litigates their last case. I looked at the so-called Mueller report, the report that was issued.
The Weissmann report.
One of the issues that was examined by Robert Mueller was the question of a president who, and this is going to be, I'm going to somewhat change the facts, but a president who fires an FBI director and assume that that is being done for the purpose of protecting, and this is where the change is, protecting the president himself, so that you have the president having the power. There's no question that the firing is something that the president has the power to do. The FBI director reports to the deputy and attorney general in the Department of Justice and is appointed by the president and can be fired. But the twist is that it is being done for the improper purpose, and assume that, there's, in this situation, for this hypothetical, that there's dispositive evidence that it's being done for the corrupt purpose of insulating the president from a criminal investigation. You could obviously change the hypotheticals in various ways. And I thought I'd quote from something that is in the Mueller report for those people interested. It's at page 169. It goes on, and there's some more on page 174, which I'm going to crib from. But the reason it's particularly interesting is that one of the members of the Mueller team was Michael Dreeben, longtime member of the Solicitor General's office, and he worked on Special Counsel Mueller's team. He is also now working for Special Counsel Jack Smith, and I'm sure has had a very strong hand in
counsel of record.
Yes,
He'll argue the immunity test next week.
exactly.
Yeah.
He is going to be arguing this, and so his reasoning is actually something that you can read not just in the briefs that are in the Supreme Court, but you actually have a preview, a very detailed one, as to how he thought about this hypothetical, where this is the quote from, without saying that he specifically wrote this statement, applying...
I think you just broke some news, Andrew.
It was just in the air in the office.
Yeah, exactly. Applying the court's framework for analysis, we concluded that Congress can validly regulate the president's exercise of official duties to prohibit actions motivated by a corrupt intent to obstruct justice. And one of the things which Trevor will like to hear is that he did think that there may be a difference between firing of a subordinate officer, an FBI director, as opposed to a cabinet-level official, where he thought that might go too far in the balancing as to whether that would be something that you could do even if done corruptly. And finally, there's a wonderful quote from Samuel Johnson that he includes, where one of the major points is that the president is bound to uphold the law and to faithfully execute it, and quotes from Johnson's own dictionary about what it means to be faithful to the rule of law. So in that situation, which is one that was actually confronted by this country more or less, in terms of a president being able to take action where the distinguishing feature is the intent behind the action, not so much the action itself, the actus reus. I mean, how should the court be thinking about that issue? And that's one I really can see coming up at the argument 8 days from now.
Well, I don't have pages 169 to 174 of the Mueller report committed to memory, so I would have to. I mean, so you said that following this reasoning, I'm curious what court decision, if that passage or those passages are even based on. But I think it's an important hypo that goes to the a little bit to the Zivotofsky and recognition issue. Like, so the president, if you think that there are a small set of powers that are kind of core Article 2 powers, and the recognition power, and maybe the pardon power, and maybe the unenumerated but apparently really important removal power, that maybe that's a list that might maybe not exhaustive, but the court takes extremely seriously this expansive power the president must possess under Article 2 to control subordinates, which the court thinks a power to remove is a really important kind of enabler of the kind of actual power to direct the execution of the law. And so, I think if you took this kind of set of exceptions really far, then maybe the president, in the exercise of the removal power, enjoys either immunity or any substantive limitation of that power in the form of a statute that might be applied to make criminal some exercise of the removal power might be suspect, however you frame it. That doesn't seem right to me. I think that the application of a generally, use of a generally applicable criminal statute against a president who exercises for unlawful reasons a power that for normal, for lots of reasons, good reasons, bad reasons, I just decided I don't like the look of you, your shoes bother me. Like, the president can remove people for all kinds of reasons. I think we all pretty much agree on that. Although I'm not sure that the FBI director and the attorney general, there's any difference the Supreme Court would recognize as to those two. I actually kind of think I have a quirky view that because there's a term, attached to the FBI position, then maybe that actually is different. But everybody seems to agree that principal officer and the president has to have, kind of authority to remove for good reasons, bad reasons, any reason. But that doesn't render inapplicable a criminal statute. And yet, let me maybe say one more thing that's going to sound hedgy, which is that I think that a prosecutor would proceed really carefully and a court would proceed really carefully in making, whether it's a formal use of not to require a clear statement, right, an explicit statement. Marty Lederman has a good amicus brief about this that says, it can't possibly be right that Congress has to explicitly say with every criminal statute, and this applies to the president, in order for a court to understand it applies to the president. That's totally unworkable and unrealistic. So maybe there are some statutes that under some circumstances there's reason to worry about the application when there's a real core exercise of Article 2 power at issue. But I actually think the corrupt removal to protect oneself and to obstruct justice, maybe for, after taking a monetary bribe, like those kinds of hypothetical applications of an obstruction of justice or related statute to presidential removal, I don't think sort of crosses the line into this area that maybe we all agree to some degree might exist and be insulated from prosecution or maybe be subject to some understanding of immunity.
George and Trevor, you look like you're going to jump in.
No, I agree. And I look at the easy case, the case that makes that analysis to me easy is, suppose it were bribery. What if the president has the removal power, no question about it, but what if, the president had some civil litigation that didn't involve his office and he had an $83 or $88 million judgment against him and he needed a supersedeas bond to appeal, and somebody said, well, if you fire this person, I'll post the bond for you. He's got to go to jail for that, right?
Yep.
Okay. I guess the panel's over.
Our work is done.
So I think I'm in full agreement with what both Kate and George have just said. The bribery, further hypothetical, I think is helpful. You can think of it in lots of different contexts, but let's think of it in connection with a power that is surely in that list where the president wins in Youngstown 3 at the lowest ebb, the pardon power, right? And so suppose the president pardons someone because and only because they were bribed to do so. Took a bribe, issued the pardon. There are accusations that President Clinton did that at the end of the Clinton administration, and I don't mean to be opining on the soundness of that accusation, but just imagine. So are we faced with a choice that, wow, in order to uphold this idea that the pardon power is exclusively the president's, we'd have to say there's either an immunity or a substantive constitutional impediment to prosecute him for taking the bribe? I think the answer is no. I think you can disaggregate the things, and I think my view would be you can do it that same way for removal. What do I mean by disaggregate? On the removal hypo or on the pardon hypo, I think the removal stands. I think the pardon stands. But if it was done for a corrupt reason, if it was done illegally, the whole thing about laws like bribery and extortion and those kinds of things is that often what is made illegal is the doing of two things together, where each one of them could be done on their own lawfully. It's the connecting of the two things. And so we shouldn't be surprised that the underlying action, the pardon itself, not only lawful, exclusively the president's decision to make, just like the removal. So I think On my understanding, I think the FBI director remains out of office, and the pardon remains valid, but the president is prosecutable. And now just one further point here. Another way in which Trump's briefs in this case, I think, are way over, and Marty Lederman did do a good job here, although I don't completely agree with his account that there is no such thing as a clear statement rule. Sorry, that's a big aside. What Trump does in his brief on this question is to claim that this notion of a clear statement rule, that wholly aside from constitutional immunity or anything, Congress just can't regulate the president with respect to official conduct unless it says, and we mean the president too, in every statute. The Justice Department, which has articulated a clear statement rule, has never articulated it that way. The idea is not that every statute, no matter how it would touch on the president, has to be explicit that the president is covered. It's only if application of the statute to the president would implicate core constitutional responsibilities of the president. And I think the way to draw the distinction here and allow the bribery statute to apply, or allow the obstruction of justice statute, I think that's hanging in the back of Andrew's hypothetical to apply, is to distinguish between the discharge of his core responsibility and the possessing of a prerogative to decide whether to remove this officer, and the illegal obstruction of justice, the corrupt purpose.
That sounds kind of like what the Mueller report said, didn't it?
I think it didn't go
quite that far.
But
I think I just remember that was kind of the debate at the time, right?
Well, so let me push back, Trevor, to ask you a question about if you let stand the removal. Essentially, what you're saying is that the president in that situation can be prosecuted for the obstruction, but they basically can get away. It certainly maximizes their ability to not be prosecuted for the substantive offense that they're being investigated for.
Yep.
And so is that really the way that presidential immunity should work as a doctrine where that's the result?
Well, I think
you could analogize this to sort of getting rid of, the Saturday Night Massacre.
Yeah, I think there are lots of circumstances in the law where ex post our ability to restore the status quo is limited, and it's one reason why we speak of the criminal law as having, what we hope, an ex ante deterrent effect. So to take a preposterously superficial hypothetical, holding someone criminally liable for homicide can't bring the person back to life. And so too here, I think the fact that he might have, quote unquote, gotten away with it may be a feature of the fact that the president does possess core unregulable powers. And the hope would be that knowing that the president is subject to criminal prosecution for taking bribes or for obstruction of justice would cause him not to do that. But I do think the consequence of saying, for example, that the pardon power is exclusively the president's is that the pardon itself can't be undone.
So I wanted to turn to something that, Trevor, you alluded to, but George asked you about, which is sort of one of the ways that something could happen in the Supreme Court that leads to further delay, which is that the court comes up with a rule that isn't, there's absolute immunity in all situations, but says there is actually a factual call here with respect to what is within the official duty, the outer perimeter of the official duties. And we may all think that seems laughable, but there hasn't really been fact-finding on this, and we're going to look at the D.C. Circuit Blasingham case, and we're going to send this back to the district court for fact-finding, and all of that fact-finding can be reviewed because it's in this immunity context prior to trial. In other words, the normal rule that you wait till the end of a case for appeals, that may not apply, so that we're going to have a hearing and then we're going to have appeals, and that means for those people thinking that there's going to be the sliver of a chance, because the moon and stars and sun, although maybe I shouldn't say the light of the eclipse, but there will be, that's over and it's not going to happen for another millennium. There isn't going to be a DC trial before the general election. So walk us through sort of whether you think that's possible and what you think could happen in that if the court goes down that road. Should the court be bound by what's in the normal rule, which is in the indictment, or should there be actual hearing? And is that necessarily so bad if we can't have a trial, if we end up with a hearing before Judge Chutkan on this issue? George, you want to take that?
I don't know what the inquiry would be. I don't know what the remand would be for. I mean, it strikes me as a question of law, not a question of fact, as what, if it's an outer perimeter standard. Right. And I just don't see, I understand the practicalities in terms, why they did it in the civil case, because that is the standard in the civil case, but I don't understand how it could possibly work in the criminal context.
For whatever it's worth, I think I agree with George that the remand that could happen, that would slow things down, is essentially reminding us again what is in the question presented before the Supreme Court and what is not. If Trump wins on the issue before the Supreme Court, so that is that his position is that a president is immune from criminal prosecution for anything taken within any conduct taken within his official capacity. If he wins that, then there is going to have to be a remand and I think a pretrial hearing to try and sort out on the allegations in the indictment which of those actions were official conduct and which were not official conduct. That's sort of the blasting game thing. I think the only way he wins on that issue before the Supreme Court, though, is if a majority of the court becomes convinced that the only way to protect the legitimate constitutional prerogatives of the president is to hand Trump a win in this case, and the court should not take that bait. So if there are lots of ways for Jack Smith to win, if he wins on any of them, I don't think there will be a hearing. I agree with George. I don't think there'll be something to sort out pre-trial on remand.
But it is, I think obviously the court should not, and I think most likely the court will not hand Trump that kind of victory, but I do think the question grows out of this, I think maybe dawning awareness that folks have that actually it doesn't necessarily completely end the proceedings if he does win, because right. The more you dig into the allegations, not just in light of the blasting game case, but just in general, some of the conduct alleged can just be characterized as an alleged conspiracy with private parties to pressure state officials in a way that has no plausible connection to the official duties of the president. And so whether you characterize that using the blasting game, official versus campaign conduct, or just ordinary criminal conspiracy, not plausibly connected to any official responsibility or duty, whether or not he's a candidate, that I think still does preserve the possibility that a lot of this conduct could be subject to criminal proceedings that survive a win on this question in the Supreme Court, but on the timing issue, even if you did a really fast mini hearing on this, what can we carve out as not official acts? And then I think you maybe do, it's both law and fact, I think. It's not impossible, but it's exceedingly unlikely that anything is going to happen in time for an actual trial on the remaining non-official conduct allegations before the election in November.
So one thing I've been thinking about, and I think some of what you're writing has sparked this, is I agree with you that this would be in the sort of the worst case scenario where Trump wins on sort of the law point, and it goes back for a finding, like in Blasingham, about what is official or not official. They don't accept the allegations in the indictment as on their face, and says you need to actually have a hearing. As long as there's not going to be, assuming that the court is going to sit on this so long that there actually isn't the ability to have a trial, from Jack Smith's perspective, and maybe even the country's perspective, that hearing may be the substitute for where they're actually, it's not the same, it won't be the full panoply of evidence, but you actually could end up with basically sort of a win.
Trial.
Exactly, where you actually, the court may be thinking that they're slowing this down, but in fact, they end up handing the ability for the court to have that hearing. And it may also be one where the court wouldn't, right now there's this, I try not to do math in public, but there's this 88-day problem, because Judge Chutkan issued a stay 88 days before the March 4th trial date that she had set. So presumably when if she were to get the green light, which I think she will, she is going to give the defense something close to, either 88 days or something close to that. But if the issue was not the trial, but a hearing,
That's interesting.
that
You
would
can
be a
expedite-
way you could shorten this all up.
Yeah.
And essentially,
Do this in the summer.
since the summer is now free, because we will be done with the Manhattan case, and it doesn't look like any of the other cases is taking up that space, there is a way that there could be sort of a rabbit pulled out of this.
That would be the dog catching the car.
Exactly.
Although, I mean, and then we have a Supreme Court ruling that presidents are absolutely immune from criminal prosecution. And like a short term, maybe there is some way to make political gold out of this. But I mean, I just find that such an alarming prospect to even sit with.
I agree with that.
Right. So one of the questions I had for all three of you is, so if you were one of the justices 8 days from now, what questions would you have for either side? Kate, do you have an idea on that?
I can offer a couple. I mean, one a little bit goes to the last question you asked, which is, could the justices? We don't know if this trial could happen, or this hearing that could turn into something like a trial, an airing of the details of the allegations. But there's a good piece a couple law professors at Duke had in Slate last week that suggested that actually the special counsel's office should use the Supreme Court argument as an opportunity to do that, because this actually is the only really guaranteed chance they have to speak to the American public, and that they should focus on the factual allegations. And now that's not the typical stuff of Supreme Court arguments. That's not the way Michael Dreeben, who's argued 100+ cases, is like ordinarily. I don't think I don't know him. You do, obviously, Andrew. Doesn't seem like his style, as far as I can tell, to like treat the Supreme Court argument like he's making an opening statement before a jury. It's not how it's usually done. But I don't know. Maybe there was something to that. So questions that actually do allow some discussion, not just about founding era history, not just about the cases on civil immunity, but actually about the underlying allegations. I actually thought Elizabeth Prelogger did a nice job in pivoting a couple of times yesterday in the case, the Fisher case involving a different January 6th defendant. Thomas's opening question characterized this the underlying conduct as protest, and she pivoted, I think, very, very explicitly to the detailed allegations of violence and harm. And anyway, so I don't know exactly what the kind of analog of that is, but I feel like something like that would be good. I feel like I would like Trump's lawyer to be asked whether United States versus Nixon was correctly decided. I just feel like I don't know how to square their arguments with it, and maybe they say no, and that would be really revealing. So I would like that. I want to understand their position on Marbury, so I guess I would ask. I hope the justices, as also a common law professor, like I'm really excited for my students to actually get to hear the folks debate, understand that we all struggle with Marbury the way you guys do. But that's a few ideas.
George, Trevor.
I'd like to hear more about SEAL Team 6.
Yeah, I think they should. I think they should ask, and I will be surprised if Trump's team is not asked. Do they stand by their answer on SEAL Team 6?
Yeah.
Because, in fairness, they should be given opportunity to recant a preposterous position, and although nothing in their brief retreats from it. And to be able to cite the transcript of the oral argument where they double down on SEAL Team 6 will be effective. I think then on the other side, Michael Dreeben should be asked to bring out what he says in his brief about why Trump's litany of past presidential actions, and he cites FDR's involvement in the internment of Japanese Americans during World War II. He cites Obama's drone targeting of Anwar al-Awlaki and various other misdeeds going all the way back. I think you might cite Andrew Jackson and the Trail of Tears even. So the brief does it, by my lights, the special counsel brief does a great job of showing that federal statutes didn't prohibit most of that stuff. So there's no question of prosecutability, and reminding the court, which is, the members of the court, they're going to have contempt for this idea because they're not interested in any institutions other than their own. But they should be reminded that the court's position across many decades is that an important way that our government works is you shouldn't just assume there are laws covering everything, and Congress decides to criminalize some things and not others. And so the absence of criminal prohibition in all these parade of horrible hypos that Trump's brief has trotted out was, I think, effectively shown in Jack Smith's brief, but I just think there should be a reiteration of that tomorrow.
So one question that Ryan Goodman definitely teed up in thinking about timing, which I wanted to ask you about, was to ask questions of the Trump counsel as to why it is that on the only issue before the court, which is the question of immunity, it is not the issue of the timing of the trial. That has been decided. That has not been appealed. That it wouldn't be appealable in this context. What legitimate argument they have for the court not issuing an expedited decision? Because as Ryan has pointed out, the position of Trump's team in at the district court level with respect to the gag order was that this indictment is not just a witch hunt, but that the gag order is interfering with his ability to run for office. So both of those are reasons for an expedited decision, unless your view is if you're ruling in my favor, then you should expedite it, but if you're not, you should slow it down. But
that is for sure his position.
I know,
yeah.
but that's like get him to say, that is his position, but it's like ask that to sort of force the question of please articulate that. And that sort of raises sort of, I guess, since you...
A point of information.
Yeah.
If they take to the last day of the term to issue a decision and say it's 9-0 in favor of Jack Smith, when is the trial? Under the 88 days.
Yeah, so I mean, this is one of these questions where you could end up with, and Melissa and I have talked about this, which is you could end up with a very, very flowery decision about nobody is above the law, that applies to up to and including the president, and lots of great language that we look to and say it's sort of the opposite of the a decision that says we're sending this back, and you think this is great. But they issue that decision on the last day of the term. I mean, remember, we're hearing this case on the last oral argument day. They could have heard this case when Jack Smith initially asked the court to leapfrog the circuit and to hear it directly from the district court. So that would have been months ago. They also scheduled this with 2 months of briefing in a case that was clearly briefed and ready to go. So you count 88 days from, let's say they issue this on the last day in June, then you have essentially 3 months from that, and then you have a real issue, I think, for the court, which I think might also be appealable, about scheduling something at that moment in a presidential election.
But doesn't that assume, you know way more about these kinds of rules, Andrew, than I do, but I think we're assuming that Judge Chutkan would be inclined to give the parties some large fraction of the 88 days they would have had on the original trial schedule. But isn't that committed to her discretion? And and assuming an opinion that says nobody's above the law, blah, 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 wouldn't she feel a bit of an implicit directive from the court to make it possible for the trial to happen in a month earlier than October?
And what basis would there be to reverse that discretion?
Well, I mean, look, I think, one, that it will get appealed. I mean, but she definitely could try to shorten it up. I think the two things that I would expect is that Jack Smith is going to do the sort of slim to win approach, which is he is going to give her some reason to say this case is going to be shorter and narrower in order to make an argument for why the time frame should be shorter. The other is, remember something that she said at the very outset of this case, which is that she said the time frame for the trial can be shortened based on your conduct. That was to the former president, saying that essentially if you I have to come up with something short of sending you to jail to control your behavior. Well, there's no question that there will be a record of his continued conduct.
Well, he's been very good, right?
Yeah. And so I think it's a second reason that she could shorten it up. It's still, I think she would have the trial, but it is one that still, I think the earliest, would be, sometime in August. That's just a guess.
Yeah, that's fair.
And on the slim to win theory, the Supreme Court may force that on Jack Smith if it throws out the two of the four charges against Trump. It'll just leave the
Fisher case.
So if Fisher wins and the court says this, obstructing or impeding an official proceeding theory does not apply here because it's like a document tampering statute, which another provision of the statute is, but not this one. But that seemed like where the court was going. Then there's just the conspiracy to defraud and the deprivation of rights charge. And so then maybe I could see her saying, well, yeah, I said 88 days, or I implied it. I don't know if she said it explicitly, but I implied something like this when we had 4 charges. This is a totally different picture right now, and you certainly don't need all that time now. So it does not seem to me like she's in any way bound to that number.
I do have one just thing to confess about the timing. The waiting for the oral argument until April 25th is my fault. I asked the court to delay until after the end of the semester because I did want to be able to preserve this kind of case for the exam in con law, and so my bad.
Yeah. Okay. Thank you. Are there anything else you want to get off
News
your
you
chest?
can use. Yeah.
News. Yeah, we're any reporters.
Okay, so students, any questions? There are microphones on either side, so come on up and use the microphone so that people who are listening in can hear you all.
Hi. Thank you all for taking the time. I think as law students, it's concerning, but also intriguing to be living through legal history. So thank you. But my question is, we have seen the Supreme Court intentionally, it seems, decide issues on narrow grounds, either as a show of judicial restraint or to kind of move the law gradually. There aren't many cases about presidential immunity, and obviously none about presidential criminal immunity of this type. So in your view, are there responsibilities that the Supreme Court or any lower courts have when they see cases like this to articulate broader principles or parameters that might extend beyond the boundaries of the facts presented in this case, where in other situations they might not?
So that's a great question. I might broaden it to be, do you think that might be one of the reasons they took the case? Because I think all of you are saying that even if there is immunity, it's not going to apply to this. It shouldn't apply to this case because we don't fall into the sort of, I'll call the Trevor Morrison rubric.
Don't call it that.
Yeah, I know. I think it's a really nice question. I think that there's some evidence that in these cases involving the asserted immunities of the president, the ordinary longstanding rule, I don't know how much they abide by it these days, honestly, but that they should decide cases on narrow grounds where they can responsibly do that. In United States versus Nixon and Clinton versus Jones, in Vance even, like the court unanimously or nearly unanimously rejects these really broad assertions of presidential prerogative and immunity, and I think does it in kind of more sweeping, at least language, than is strictly necessary. And so I actually think, that is reason to believe maybe again, this is a different court, so I don't know how much past is prologue here, but I do think that might suggest that they will not necessarily adhere to some narrow, result in the case.
This is one of those, it's a great question. For me, this is one of those cases or sets of issues where each time I think I know what it means to rule narrowly, I kind of turn it upside down and well, isn't that ruling broadly for the opposite proposition? And so to Kate's point, I think I'm hoping all the justices, a supermajority of them, will want decisively to reject the sweeping theory of immunity. And you can do that by ruling narrowly. You can do it because if you hold Trump not immune here, you have for any reason, you have necessarily rejected the idea that former presidents are always immune. I think the other thing for me, a number of the justices I won't be surprised if they are eager to do, is to make sure that in holding Trump not immune, as I was suggesting before, they don't mistakenly send a signal that there is nothing to protect the criminalization of core presidential responsibility, core presidential conduct. The court has 3 members who've served in the White House and who have, in their own professional background, experience with thinking about the need to protect presidential prerogative. That's the Chief Justice and Justices Kagan and Kavanaugh. And I wouldn't be surprised if they are all somewhere near the same page here. And I think there's a way to do something that's helpful for future cases by rejecting some absolutist positions, but then also ruling otherwise narrowly on this, on this case as to why there's no immunity here without reaching broadly in the other direction and saying there could never be immunity for a prosecution of a former president for official conduct.
Yeah, I agree with that. I think that's why they took this case. I can't explain the timing of it, why they decided to hold the argument.
Other than my exam.
Yeah, well, your exam. But I think that's why they took the case. I think they felt that they didn't want to leave a circuit court decision in place on something that was potentially so important that could affect something in the future. They just want to leave the door open in some fashion. But the problem is they shouldn't overthink it, because the hypotheticals you can come up with are just infinite. And this is an easy case, and they can't lose sight of the fact that this is an easy case for the reasons that the D.C. Circuit panel said.
Yeah, I agree with that.
So I have a question that's somewhat related, which goes to the idea that there is this stay because of immunity being argued, and you have this, again, just to make sure our students understand, the normal rule is that you appeal things at the end of the case and you don't get the stay beforehand. Now, for things like double jeopardy, where there's a colorable argument of it, you do. And it doesn't come up a lot, but that is the argument for why that is happening here, that you have a stay in this case, because it should be argued beforehand, meaning if you were immune, you shouldn't be suffering the consequences of a trial. But if it's clear that what the court is doing is thinking about the question that was asked about sort of big picture, what do we want the law to be? But we know in this case it's not applied. It's not going to be the issue. Why is there a stay? I mean, this just seems like one where could this have been litigated or decided differently, or should the law be different, that where the district court and the Court of Appeals could have been like, yes, these are potential issues. The Trevor Morrison examples, I know you hate this, you're just like, okay. So that there may be areas that fall into presidential immunity, but it's not this case. So that the whole purpose for having a stay, which is something that is antithetical to certainly the public's interest in a trial of criminal matters, is being undermined needlessly.
I think it's kind of inescapable. I think the answer is yes, that this delay is unfortunately leading us into this position, and to, invoke argument that I know our Harvard colleague Jack Goldsmith has made. There's no getting around that this trial, if it happens before the election, is going to be standing in some tension with a longstanding Justice Department norm of not wanting to conduct trials at a time when they're likely to have an impact on an election. I mean, the other side of that, obviously,
whose fault was that?
Yeah, exactly. So that's. I don't mean to be opening that, but I just think that's an expression of the cost that Andrew's talking about here. For me, not to tout my own position on this, but one reason why I've wanted to say that the constitutional limitations I think do exist on the prosecutability of a president, these separation of powers constraints. One reason why I think it makes sense to call that immunity is to say, in a case where those things were legitimately implicated, I do think the president ought to be able to raise it pre-trial and take an appeal if those arguments were denied. Now, if we already had Trump versus United States on the books, making clear the boundaries of this, there would have been a much better argument for saying, the arguments you're making here, Trump, don't sound anywhere in the doctrine are preposterous, and they're like making a double jeopardy argument at the beginning of a trial where there is no double jeopardy argument to make. You wouldn't be able to take that up on appeal. But I think we're kind of stuck with the uniqueness of this. Trump, in just about every area of the conduct of his presidency, forced the constitutional issue in ways that courts had to answer questions they'd never before had to answer. And one consequence of that is sometimes you need to live with the delay. I think it's unfortunate but unavoidable.
I want to thank all three of you for taking the time. It'll be fascinating to see.
We hope you enjoyed this discussion. You can read all of Just Security's coverage of the Trump trials, including expert analysis of presidential immunity, on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen.